Hello, my wonderful people. How na day? I greet you in the name of God, and I bring you good tidings and great good news too. All these times that since Queen May case has been in the court system in Nigeria, and everybody, including myself, everybody will be saying, "Oh, to estranged husband." We've been saying to him, sign the divorce, sign the divorce, sign the divorce. Even when he himself comes on social media and he will be bragging, I am not going to sign the divorce. I'm not going to sign the divorce. Nobody is going to make me sign the divorce. I don't want to divorce my wife. Because you know that this our actor has, he speaks from two sides of his mouth. Tomorrow he will say, return my bride price. Next tomorrow he will say, I don't want to sign the divorce. Yesterday he will be begging, So he speaks from different section of his mouth. So DPA, I like this lawyer a lot. Because it's actually opening our eyes, both men and women. It's not that he's saying you go and divorce your husband or go and divorce your wife, but as a couple, he's trying to enlighten you, to teach you, to educate you, for you to know your part in your marriage, for you to know your rights in your marriage. What he's saying, he's not saying don't respect your husband or disrespect your husband, no. But what he is teaching the men and the women how to treat your spouses and also your rights in your home as a husband and as a wife. So this notion that all of us had that, oh, Yul is the one refusing to sign the divorce papers, no, that notion is wrong. Totally wrong. So the question is, does your husband have to sign the divorce before you can divorce him? The answer is no. According to him, according to the laws, whether it's here in the United States or back home in Africa, the man does not sign the divorce papers. So that, in fact, Queen May is so intelligent. That girl, she is so intelligent and smart. That was why she took the case straight to court. Because say if you say that this guy with the coconut, he call himself that, or I did not call him, or he calls himself coconut head. If you go by him, like he said, he will never sign the divorce. So this Harvard-trained USA lawyer is giving us a lot of education. Is educating us, is giving us orientation. I don't even know what to call it. Classes almost on a daily basis for free on his page for us to know what we have or what is our right in our marriage, in our homes. So my people, I'm going to play the voice note so that you all will listen to him and hear him say, so that it won't look like trying to repeat exactly what he said. Because these things, I beg, make una listen to it. Even if you are not the one that need it, you might know somebody that knows somebody that need this counsel that this man is giving us for free. So my people, please listen. It's very, very important.
Too many people believe the wrong thing.
Let me start from the beginning.
Trying to correct them.
Exactly.
I have had people tell somebody, a man that was sued for.
Okay, listen. It's very important that.
Hello, guys. We are going to have a little further discussion on an important subject matter in family law.
Family law.
And I have been trying to answer this question for a long time, but it's been difficult for me because a whole lot of people believe the wrong thing. And when too many people believe the wrong thing, it is a risk trying to correct them. I have had people tell somebody, a man that was sued for divorce, and they're telling the man, sign the divorce, just sign the divorce.
That's what we've been saying, no?
Sort of created impression that the man needs to sign the divorce in order for the woman to have a divorce. So many of you thought so. And I asked myself, why do they believe that the man has to sign the divorce in order for there to be a divorce. In other words, it implied that the man has to give his permission in order for the woman to be divorced. That is, if the man doesn't sign, then the woman wouldn't get it. That picture is wrong. But I know where you got it. You got it from the movies. In many movies you've watched, you will hear a man say to his wife, or the wife say to the man, I will never give you a divorce. I will never give you a divorce. I will never sign a divorce. So from there, many people assumed that you cannot divorce your spouse unless your spouse signs or agrees to divorce. That's not true. That's no longer true. In the past, many decades ago, or even centuries ago, divorce was not allowed. There was restriction on divorce. It was difficult to divorce anybody. Because in those days, the churches were in control of divorce. And even till today, the Catholic Church doesn't allow divorce. Instead, they turn around and call it annulment. So if you want to break a marriage under the Catholic law, they will not see it as divorcing. They will treat it as annulment. That is, they assume that the marriage never existed. Annulment is what happens where the marriage never existed or were never proper. So, because of this old attitude against divorce, there were all kinds of obstacles placed on the way of somebody trying to get divorced. And one such obstacle was that they required the person you want to divorce to agree to divorce. And based on that old tradition, when you watch movies today, you will still hear somebody say, I will never give you a divorce. I will never give you a divorce. Or you say, okay, go and get the divorce, I will sign it. Go and get the divorce paper, I will sign it. But it's not true. You don't need the permission of the person you want to divorce in order to divorce him. In fact, he has nothing to sign. The person you want to divorce has absolutely nothing, cannot sign the divorce. The court will divorce you even if you don't agree. The court will divorce you even if you don't show up in court. The court will divorce you even if you don't respond, provided that the person who sued you for divorce has met the requirement of law. Many women come to us and say, I don't know his address. He will not come to court. So that means I can't divorce him. I say, no. If he doesn't come to court, if he doesn't respond, it makes it easier for us to divorce him. Absolutely. If you don't show up, if you don't respond, then divorcing you becomes very easy, because what the court will do is to move the case from contested divorce to uncontested divorce. In other words, your absence or failure to participate will make the divorce easier, because there's no challenge to the divorce. The court will grant it easily. What I believe caused confusion in this particular case, when people are saying sign divorce, let me tell you how the confusion arose, how that issue of signing came up. You know, before the court, there are two types of authority the court has. We call it jurisdiction. There is the subject matter jurisdiction, and there is the personal jurisdiction. Subject matter jurisdiction is the power of the court to hear that type of case, to hear the particular type of controversy. For instance, it is only the High Court in Nigeria, State High Court in Nigeria, that has the jurisdiction to hear divorce cases if the marriage was under the Marriage Act or statutory marriage. So you cannot take your divorce case to a magistrate court. Magistrate court has no jurisdiction to hear divorce cases. If the marriage is customary law marriage, then only the customary court has jurisdiction to hear that controversy. So we call it subject matter jurisdiction, because the courts are divided in such a way that some courts hear certain type of cases but not others. Some courts hear certain type of cases but not others. So when a court can hear all manner of cases, we call it court of general jurisdiction. But those courts are very rare these days because courts are confined. There are some cases that cannot go to high court, it must go to magistrate court. There are some cases that can go to both, so you have to choose. So we call it subject matter jurisdiction, the power of the court to hear a particular type of case, subject matter jurisdiction. Then the second type of jurisdiction is called jurisdiction over the individuals, over the parties. The power of the court to make orders against a particular individual, the court must have a jurisdiction over that individual. So, in addition to having power to hear a particular type of case, the court must also have the power to hear that particular type of case in respect of these particular individuals. Subject matter jurisdiction is decided by law, the statute. For instance, the Matrimonial Causes Act, which is the procedural law governing divorce, separation, annulment, if the marriage is under the Marriage Act in Nigeria. That act, Matrimonial Causes Act, gave the subject matter jurisdiction to state high court. Because it's state high court, you cannot take it to federal high court. Federal high court has no subject matter jurisdiction over divorce cases. So a lawyer will first determine which court has the right subject matter jurisdiction. Absolutely. Then you will also look to see if there are what we call territorial jurisdiction or forum jurisdiction. I'll give you an example. If you have a contract in Lagos State and you have a dispute over that contract which was formed in Lagos State, you cannot go to Ogun State or Imo State High Court. It has to be in Lagos because it is territorial. That particular controversy, contractual disputes are territorial, in addition to subject matter. However, interestingly, when it comes to marriage issues under the Marriage Act of Nigeria, all the state high courts have jurisdiction. So even if you married in Lagos, your husband can file for divorce in Maiduguri, in Borno State. Of course, that will be a problem. When you live in Lagos with your husband and he goes and files in Maiduguri, Maiduguri will have subject matter jurisdiction. It will also have jurisdiction of a venue because the law gave the entire country, turned the entire country into the same forum. So, but now let's go to the personal jurisdiction. We call it in the Latin term, its original term, jurisdiction in personam. Jurisdiction in personam, which means the court has jurisdiction over the particular individual. How does the court acquire jurisdiction over an individual? The court will serve you what we call summons. Summons. That is, it is a notice for you to appear in court. If it is a civil summons, it's up to you to come or not to come. But if you don't come, there will be consequences. If it is a criminal summons, you must come. People are
listening, right?
Because if you don't come in criminal summons, bench warrant will be issued against you, or arrest warrant will be issued against you for you to be arrested. But in a civil matter like divorce, which is a civil matter, no, you will not be arrested. So, but for the court to get jurisdiction over you, they will serve you summons. And for the summons to meet the requirement
this knowledge is giving us is for free.
In accordance with the Constitution,
and I hope everybody is listening.
The summons must contain the following. It must contain the notice that a petition has been filed against you, asking you to come if you wish to defend it, or to file an answer if you wish to do so. I'm warning you that if you don't file an answer, the case will proceed without you. That is the summon. But because due process requires that a person who has been sued in court should know the reason why he's sued, he must know the allegations against him. And that is then when you file the petition itself. The divorce petition contains the allegations, contains the facts of the case. Now, another due process requirement is that the person you sued must have adequate opportunity to respond. To give him adequate opportunity to respond, the court will give him 28 days to respond to the petition served on him. So, in the normal circumstances, the court bailiff will come to your address, the address that is written on the petition, and give you the summons containing the petition. We call it serving you the process of court. The essence of serving you that document is to give the court jurisdiction over you. Once you are served that document, the court now has the power to make orders against you. Without you doing serve this thing, the court cannot make orders against you. Except in very rare cases, what we call ex parte proceedings, emergency law. That is something else we discuss some other time. But when they serve you the summons, you can take the summons and acknowledge that you received it. That is when you sign. I, so and so man, received a copy of the summons on so and so date signed. When you sign it and give it, because the bailiff will come with 2 copies. They serve you the original, they give you one to acknowledge that you received the original. Now, when they give it to you, you can be a gentleman and take it and sign it, and there's no problem. In fact, before they come to your house, some people live in gated community. So, if you sign it, there's no problem. You're signing acknowledgement of receipt, not the divorce, not the divorce. You are signing an acknowledgement that you received a copy of the divorce petition, together with the summons of the court. In that particular case that you people know, which is where you got this idea, we are here, signed the divorce. They came to serve the summons on the man and his girlfriend. They came to serve them summons. The bailiff called them on the phone because your number is stated there. They said, hey, I'm bailiff. I am from Lagos High Court. I've come to serve you papers. A gentleman will say, okay, this is where I am coming to my place. So, but this particular man began to lie. He said, where are you? He said, well, I am at so estate. He said, no, I don't live there. I'm not there. He didn't know that the bailiff already asked the gate man. If they saw him, they said, yes, he lives here, he's there. So when he began to tell the bailiff that I don't live there, then he told the gate man to say that he was not there, that they don't live there. So that was why the bailiff began to chase them around, trying to get them to accept the summons and sign it. So it became a concern that these guys are running, they don't want to sign an acknowledgement. But so what happens if you don't sign? Will you be able to block the divorce by not signing? No. You just delay it by 1 month to 2 months. Because this is what we will do. When they try to serve you that document and you're dodging and lying and hiding, the bailiff will call the lawyers and say, hey, this guy has been evading me. I've been in Enugu for 2 days trying to serve him, and he's not taking it. What do? I think, I should come back. We say, yes, come back and prepare affidavit of non-service, affidavit of attempted service. Because when the bailiff comes back, if you sign that acknowledgement letter, acknowledgement that you got this, bailiff will prepare a brief affidavit of service. He will say, I, so person, a bailiff of this court, hereby swear and state that on so date, I went to the address of so man, the defendant in this case. I served him a copy of the summons, and he acknowledged it as seen in the attached acknowledgement. He will attach it. So they'll put it in court. So when the court looks at it, the court will say, yes, the man has been served. So he knows that this case is on. Therefore, I have jurisdiction to proceed. Now, if you refuse to sign that thing, forgive me, I laugh because a lot of people think they're smart. If you refuse to sign that acknowledgement, the bailiff will come with an affidavit. The same affidavit, but the language will be different. On so date, at so time, I arrived at the address of this person with intention to serve him the process of court. I spoke to him on the phone, and he told us he's not living there, but the gate man told us he's living there. That on the next day, I came back, and the man ran away. That I did everything, but I couldn't find him. As a result of this, I wasn't able to serve. That is what his affidavit will show, that he tried to serve. Then we go back to court. We file what we call application for substituted service. Substituted service. Because you see, the law first say we should serve you directly. That's the mistake. But when we cannot serve you directly, we serve you by substituted means. We say, my Lord, we refer to the affidavit of non-service attached by the bailiff, indicating that he made effort to serve, but was frustrated and was not able to serve. On the basis of that, we hereby request the court to grant us permission to serve him by substituted means, viz. By email at this email address, by WhatsApp at this WhatsApp number, or be allowed to paste it at his gate, or be allowed to publish it in the newspapers, or be allowed to post it on the notice board of the court. The judge will look at it. The judge will see that there was an attempt to serve him papers, and he didn't take the papers. He rejected the papers. He ran away. He lied. And the court will say, based on the affidavit of the bailiff and based on the application of counsel, I hereby grant permission for service to be effected by WhatsApp, email, or whatever. And once the court does that, we thank the court, we get a copy of that ruling, we attach it together with the thing and send it by email or by WhatsApp. And then the same bailiff will do it. And the bailiff will now prepare another affidavit. Pursuant to all court order, so, I served this thing by sending it to his email, and I believe he received it. The court now has personal jurisdiction over that man. The court will move forward. When the 28 days passes, if the man doesn't file any response, the court will ask the petitioner's lawyer to set the case for undefended list. That is uncontested divorce. And they will set it for uncontested. On the trial date, the petitioner will come and testify. Given that the defendant is not responding, the respondent is not responding at all, the court will ask for written address in preparation for judgment. And the court will give judgment. So, please, I want you to understand that you don't need the signature of the person you want to divorce in order to divorce him. You don't need his permission in order to divorce him. All these things they do in the traditional setting, I will not take back the bride price and use that to delay you. It doesn't happen. in reality, unless you don't have a good lawyer. There's always something to do. We know what to do. We know what to do. All right? We always know what to do. So if he signs it, if he signs the receipt, acknowledges the receipt of the summons, then there will be no need for this extra effort that is aimed at substituted service. Because it may take you up to a month or 2 months to get the same document served by substituted names. So if you are sued for divorce, don't ignore the court. Sign the acknowledgement. Acknowledge that you were served so that the court can move on faster. If you don't, there will be substituted service. We have seen situations where some people, we got substituted service. It was after substituted service that they finally went to a lawyer and the lawyer showed up. People generally may delay. If the terms of divorce are not favorable to them, if the timing of divorce are not favorable to them, they will resist divorce. They will, and how can they resist it? They will slow down, refuse to sign papers. But once he finally shows up, the court will hear him, because some people will initially refuse to participate, but at some point in the hearing before judgment, they show up. So this gentleman was dodging his service, evading. Then guess what? It was finally served on him, because there's another thing that happens. If they see you, if the bailiff sets his eyes on you and shows you the document and you refuse to take it, he will throw it down at your feet on the ground and prepare an affidavit that it was given to you. It is still service. The court will treat it as given to you. So when finally, despite all this gra-gra, that man got served, he went to his lawyer, and the lawyer did the right thing. The lawyer said, hey, you're going to file an answer. You can't ignore it. You're going to file an answer. Because there were heavy allegations against you. Serious allegations. You must try to say something. So now, as I explained to you, a case that is not challenged is faster than a case that is challenged. Obviously. Because nobody is opposing you. You say, well, I want divorce because he slapped me, he beat me, domestic violence. And the court looks and says, where is the man? They say, the man refused to come. The judge will say, yes, we have to believe you. His absence, we believe you. He didn't challenge, he didn't contest it. And the court will grant divorce. But it is better for you always to go to court, present your side of the case. You need to be heard. Because trial involves public record. Whatever is said in trial is going to be placed in public record. Your children and grandchildren will see it. They may see it. So if you are falsely accused, you feel you are falsely accused, go to court and state the truth. Even if you are accused rightly, go to court and offer your explanation. It's very important. Don't ignore court. So, but the point I think I have succeeded in making today is, what is delaying a case, the divorce case, is not that the man refused to sign. Because there's nowhere he's required to sign the divorce. He delayed it in the beginning, but that's been over long ago. The court now has jurisdiction over all the parties. Because and not only that, the parties have all entered appearances and filed their answers. So we say that the issues have been joined by both parties. Okay? So, bear that in mind. If you don't want divorce to happen, the best way to achieve it is not by staying away from court or refusing to sign acknowledgement. They will move on without you. They'll move on without you. Okay? So, next time, when you hear people say, let him sign the divorce, that's not the problem. That's not the problem. The problem are, the court is extremely busy. Nigerian courts are extremely busy. if you want our justice system to work efficiently, we need to have 3 times the number of courts and number of judges we have now. We're a country of 200 and something million people, and we have a court system that is not even sufficient for a small fraction of that number in other parts of the world. So we need to have more courts, but we also need to improve the alternative dispute resolution mechanisms. This is why DPA began to build courts. As you know, DPA has private courts, our dispute resolution centers, where people with controversy, manageable controversy, could come and resolve their dispute in 2 weeks instead of going to the regular court and spending 4 years and paying a lot of money. So, but as it is today, the delays you are seeing are driven by the systemic problems. It's not that the case is not important. It's not that the case court doesn't want to hear it. Okay? Yes, as you know, the opponent can delay things. I'll give you an example how an opponent can delay things. If a case is scheduled on a particular date, your opponent can send a letter and say he's sick. If he says he's sick, the court will not go ahead. They will adjourn the case. And cases are adjourned month by month in Nigeria. Doesn't want to hear it. Okay? Yes, as you know, the opponent can delay things. I'll give you an example how an opponent can delay things. If a case is scheduled on a particular date, your opponent can send a letter and say he's sick. If he says he's sick, the court will not go ahead. They will adjourn the case. And cases are adjourned month by month in Nigeria, or 2 months. If it's here in the United States, if you're sick today, the judge will ask you to come tomorrow. If you're sick in the morning, the judge will ask you, will you feel better in the evening? So we're not, so here in the United States, they don't adjourn cases indefinitely. They don't even do this adjournment stuff in the US. The calendar for the case is determined upfront. We have what we call fast track, intermediate track, long track. They will set everything in advance. The judges here will say, hey, preliminary objections must close at a particular time. You know, discovery must close at a particular time. Status conference, trial. They set these things in that order. But Nigeria is still a developing country. And we don't have that system well established. That is the delay you are seeing. And of course, as I said, your opponent can create problems. But the problems he can do is to delay, not sign it. Remember that what drags a case in court depends on what the people are fighting over.
Sick, like our art of life.
Here in America, most people will agree on the main issues. They already agreed who have custom. They already agreed who will have the house. They already agreed. So the thing the court will decide will be a very tiny thing. One final issue they did not decide, agree on, the court will resolve it. But here, the Nigerian scenario, with bitterness, with problems, with ego.
Exactly, especially the ego.
The husband is angry that you dared to divorce him. So he begins to put obstacles. He will show up in court.
Can you imagine?
Or his lawyer will come and ask for
divorce, but if they want to divorce you, they will divorce you. But if you want to divorce you, they say you dare to.
Distractions that will take away the time of court. Because if you are suing somebody for divorce and the person is doing all kind of nasty things on social media, making movies, it is going to prompt you as the lawyer to divert attention to dealing with that. Because now you're telling the court, oh my Lord, look at what he published on social media, look at what he's published on social media. So that could take a whole day, a whole sitting. If the court does it 3 times, that is 3 to 6 months.
Wow.
That is how it goes. When people are acting in good faith and honestly, they go straight forward. She wants divorce. I understand that divorce is inevitable. We will file for divorce and so everything goes smoothly. So they narrow down on the issue. Okay, marital property. We agree on what the marital property is. We have 2 cars. I'm driving one and she's driving one. So we keep our cars. Ticked. Children will be with their mom because they'll be living with their mom anyway. So, ticked. Then how much are you going to pay the children? Well, I'll pay X amount. They say it's not enough. So the judge is okay. So the only thing remaining is how much to pay. Okay, let us analyze how much do you earn, how much do you earn, and the court will make a determination. This thing will go smoothly. But when you have ego, bitterness, malice, or other agenda, you drag out the case. You drag out the case, you do everything to delay the process, and
That's
it
the
will be
Nigerian
delayed. But
system
as to
for
whether
you.
you can finally block it is not possible. You cannot stop your wife from divorcing you.
Good.
No.
Good though, that was what we thought before.
Unless your wife could not meet the grounds for divorce. In other words, if she didn't state one of the acceptable reasons for divorce, then she will not be able to divorce.
Nigerian lawyers should be coming out to
Or
tell
something
people,
happens in
teach people
between
family law.
during the divorce that will cause the court not to divorce you. Let me
This
give you an example
blogger,
of what happened in
Neseve,
one
used
other
to do
case, a
it.
separate case. You'll laugh when you hear this. In this case, the man
Barrister
the woman filed
Nese,
for divorce.
she used to do it.
They were both
But she
represented by
stopped.
counsel. The case was going on. On one occasion, they came to court. The man was not there, but the woman was there. The judge turned to the lawyer, the man's lawyer, and asked him, "Where is your client?" The lawyer said, "Oh, yeah, I spoke to him. He's on his way, my lord. He'll be here any moment from now. Just give him more time." When he was saying this, the woman wanted to say something. The judge said, no, it's not your turn. Keep quiet. So they waited for 30 minutes. The man did not come. The lawyer said, "Hey, you said your client is coming." He said, "Oh, yes, my lord. Maybe I should go out and call." The woman raised her hand again. Finally, the judge said, "Okay, yes, madam. What do you have to say?" The woman said, "My lord, I want to tell you that he's not coming. He's not coming because he has gone to see his doctors. My estranged husband has gone to see his doctors. He called me last night and said he wasn't feeling well. So we spoke, and I advised him to go and see his doctor. And this morning, when he was going to see the doctor, he also called me again. I said he was at the distance, and I told him, okay, sure. See your doctor, don't play with your health, this, that." The judge looked at the woman. "Really?" "Yes."
You want a divorce?
So the judge said, "Counsel, the man's lawyer, your client was sick, he didn't call you. Your client wouldn't come to court, he didn't call you, he didn't tell you. Instead, he told his wife. And the wife was sent to come and tell us. And the wife had been advising him about his health. And the two of them have been talking. So, madam, I don't think your marriage has broken down irretrievably. If he still had to call you when he's sick, and you had to advise him on how to see his doctor, then
the marriage
is not broken down irretrievably. Therefore, no divorce." You see? Another case where a judge cancelled divorce. As the case was going on, divorce, the woman filed for divorce. Oh, no, the man filed for divorce. As the case was going on over time, the judge noticed that the woman was pregnant. The judge said, "Madam, you're pregnant?" Said, "Yes, my lord." So we're in the middle of divorce case, you are pregnant. Said, "Yes." So who is responsible for the pregnancy? The woman said, "It is the man who filed for divorce." Her husband. The judge said, so after you filed for divorce, your husband got you pregnant, right? Okay. Divorce cancelled. Because the marriage has not broken down irretrievably.
Oh my
So, but other than
goodness.
that, the court will grant divorce.
Oh goodness.
The issue is not divorce. The issue is whether there will be the terms and conditions that will go for with the divorce. So, please, in case you hear this, anybody telling somebody to come and sign the divorce, go and sign the divorce. No such.
That's what we all used to say. Sign the divorce. The
respondent has nothing to sign.
Sign the divorce.
His opinion is irrelevant. Whether he wants divorce or not is immaterial. All he can do is to challenge the allegations leveled against him. If they level adultery, just say no adultery, no evidence of adultery. I never committed adultery. I never slept with another woman. No. They accuse you of marrying another woman. You say, no, I never married anybody. We were just acting movies or making skits. It's not marriage, yo. It's only marriage on social media.
Wow.
And they say, okay, well,
Our
that's not marriage.
Kitty, they
But are you sure you never slept with her? No. If you succeed, then they say, okay, well, the reason you brought him here is because he slept with a woman, but he never slept with anyone. And you said he's planning to marry someone, but he never married someone else. So your reasons don't succeed. Your reasons fail. They say, oh yeah, but there's another reason, my lord. We've been living apart for 3 years or 2 years. The judge will say, is that true? Have you been living separate and apart? Yes. Okay, that's enough. That's enough. You get a divorce. Pop, pop, pop.
Wow.
So there will be divorce in most of the cases, okay? Nobody signs for divorce. It will be granted. And that is consistent with the world practice. Why
people,
keep
please
a person
share this
in a
video.
marriage he or she doesn't want?
Share and subscribe to my
It's
YouTube
terrible.
channel.
You can't force people to marry, and that's
I
why
hope you all
even
have
in Nigerian
learned.
courts,
This video is
when
getting
the
too
grounds
long.
for
I'm going to
divorce have
call
not
end
been
it. It's
met,
almost ended anyway. So
the judges will
please share
instead order separation.
and subscribe. And please share so that other people can watch this. This is very important. Thank you and God bless you.